Hello, and thank you for coming to our presentation today. The Law Offices of CR Abrams presents Revocable Living Trusts. My name is Sarah Rinelli. I am one of the attorneys that is going to be giving the presentation today. So, we know why you're here today. You're here because you know you need a revocable living trust, and maybe you're not exactly sure why. Today, we're going to be explaining what is a revocable living trust. You may be coming today because you already have a revocable living trust, but maybe the kids have grown up since the last time you did it. Maybe your life has changed, people have passed away, grandkids have been born, and maybe you wanted to update your living trust and you wanted to get a refresher course. Perhaps your friends and your family have hired us as their attorneys. Maybe you saw our ad in the newspaper and you just wanted to see what this is all about. And I know for a fact you're watching this presentation because you want the 50% discount code that I'm going to be giving in the middle of this presentation today. So, grab a piece of paper, grab a pen, grab an iced tea or a cup of coffee, and I want you to take some notes today. I'm going to tell you if it's very important when to write something down. But for now, sit back and relax, and we're going to be explaining what is a trust, what's a will, what is probate. Later on, we're going to discuss what is included in our estate planning package. And we're going to go over some things that may have to do with your real estate. We may briefly talk about taxes. By the end of this presentation, if you're interested in signing up, we want you to call the office. Our office staff is standing by ready to help you. And I'm also going to explain, if you do sign up and you call the office with your credit card number, how do we actually go about getting this done? We're going to be talking about the paperwork. How do we get this binder typed in your hands? And then, what happens after you've had a chance to read this? What happens during the notarization process? Now, a little bit about our law firm. We've been in business for a very long time. I'm one of the younger attorneys. I've been an attorney for over 10 years now, but we have multiple attorneys on staff. We have lots of other staff members like paralegals, legal secretaries, legal assistants. We look at your case as if we as a group work on your file together. What does that mean? If you ever need to call the office or email us or call us on the phone, come visit us in our Mission Viejo office, we do not charge any of our clients for office visits or phone calls. Not for you or your family. But when you call, you may be talking to another one of our staff attorneys. We work on your file as a group. Now, I also want you to know, there's nothing you're going to say we haven't heard before. We do many living trusts. We've done thousands and thousands of estate plans. So there's nothing you're going to say we haven't heard before, and we're not here to judge you or your family. So let's go ahead and get started. What is a living trust? In order to explain what a revocable living trust is, I just want to show you a picture of my parents. I use them as an example to illustrate the definitions. My parents, Dennis and Sylvia Rinelli, had 2 daughters, me and my little sister Denise. When I was in high school, my parents paid off their residence, and they paid off a rental property, and they paid off their cars and their credit cards. Mom and Dad, they weren't necessarily wealthy people. They started working right after high school. They didn't go to college, but they were savers. They scrimped and they saved, and they kept saving their money and paying off things as they went. My dad always used to say, Sarah, if you can't afford to buy it in cash, you probably can't afford it. And that was the motto that they lived by. After Mom and Dad paid off the house and the rental when I was in high school, one of my dad's buddies sat my parents down and said, Dennis and Sylvia, you paid off the house, you paid off the rental, you paid off your cars and your credit cards. You need to make sure that if something happens to you two, that your two girls, Sarah and Denise, get your stuff. You need a will. That's what everybody used to say, right? You need to get your will. My parents, they didn't want to spend the money to hire a lawyer to do the will, so they decided that they were going to do the will themselves. They hand wrote a will, and it was very simple. It said, if one of us die, the survivor inherits 100%. But if both of us are not living, our two daughters, Sarah and Denise, inherit everything 50-50. Now, you may be asking yourself, is a handwritten will valid? Yes, it sure is. Does a handwritten will need witnesses? Nope, but it's much better if it has two witnesses. My parents, they actually did a great job. They took their will and they put the will in the safe, and they thought they were done. Now, my parents are both very, very healthy, very active 72-year-olds. But let's pretend for a minute that my parents do die. What do me and my sister actually have to do? Well, we need to pay for the funeral. Got to handle all the arrangements. We also need to keep paying the bills. Now, I know my parents have really no debts, but we have to keep paying the property taxes, the utilities, the gardener. Perhaps there's some medical bills from the end of their life. Perhaps they went into a hospital or ambulance. I'm not exactly sure what to expect, but we know that there are some bills that we're going to have to take care of. Now, I don't know if your family is anything like my family, but my parents, they really never talked about their financial situation with me and my sister. I mean, I know that they have everything paid off. I know that they have checking and savings somewhere, but I don't know what bank they use, and I don't know how much they have saved. I'm pretty sure that they have retirement accounts or life insurance, but I'm not positive. If Mom and Dad die, my sister and I may have a little bit of a scavenger hunt on our hands to try to figure out where Mom and Dad have all their financial institutions. Maybe we go to the house and we go through the mail and the paperwork and the filing cabinets and the computer, and I know we're going to go in the safe and we're going to look for anything that seems helpful. Maybe we'll come across some of their credit card statements or their bank statements or their investment statements in the mail. Maybe somewhere in their paperwork, they've got their retirement account information and their IRA and their 401k information. Maybe somewhere they've got some insurance policies. But it is a scavenger hunt. Even if my sister and I do find their statements, the question is, what the heck are we supposed to do with all the information we've collected? I know I should probably make an appointment to go to the bank. And I'm going to start with their checking and savings account. I'm going to make an appointment over at B of A, where Mom and Dad have their checking and savings. And I'm going to bring everything I can with me when I go. And hopefully, Bank of America is going to let us withdraw their money and use it to pay for the funeral and the bills. Now, before we go any further, I'm going to give you the coupon code. The coupon code is going to be Angels Baseball. Angels Baseball. I'm going to bring everything with us that I can think of when we go to the bank. I'm going to bring the statements that I found, their death certificates, because the bank won't talk to us without those. I'm going to bring my ID and my birth certificate to prove that I'm the daughter. I'm also going to bring the will that I found. And I'm going to bring my sister, so everybody knows we're on the same page. We want to withdraw the money, use it to pay for the funeral and the bills. And if there's any money left over, my sister and I can split the money 50-50. We are in agreement. The bank takes one look at our paperwork and says, girls, I got some bad news for you. Thanks for bringing the will. Thanks for bringing the death certificates and your ID. But your names are not listed on these bank accounts. Because your names are not listed on these bank accounts, you can't have the money. You need to take this paperwork and go get it validated by a judge. You need to go to probate court. Well, that's not good. Mom and Dad, they thought when they did the will would give us access to their bank accounts. But it doesn't. That is a common misconception. We could go to Mom and Dad's checking, savings, stocks, bonds, CDs, mutual fund, money market investments, all those different financial accounts. We won't have access to any of those because we need to come back with a court order from the probate court. The will just doesn't work. Now, I want you to take out your pen and paper. And right now, I want you to write down at the top of your page, there are 3 ways to avoid probate. There are 3 ways to avoid probate, and underline it. And number 1, I want you to put next to number 1 a $sign. This is a way to make sure that your bank accounts don't go to probate. I want you to put number 1 and then a $sign, and then I want you to put 2 words. Beneficiary designation. Beneficiary designation. Also known as pay on death, POD. Let me explain what this is and why it avoids probate for bank accounts. If my parents, while they were healthy, while they were competent, had visited the bank, had been proactive, and told the banker, if we die, we want our daughters to get the money. We want the beneficiary designation paperwork. The banker would have handed Mom and Dad the free paperwork that the bank has. Every bank has this free paperwork. It is called beneficiary designation paperwork. What does this paperwork ask? Well, number 1, it asks who owns the bank account. Mom and Dad would fill in their names. What's the account number? Mom and Dad would fill in the account number. And then it's going to say, if the account owners die, who's going to inherit the money? Mom and Dad would put me and my sister Denise's names in the blanks and that we inherit the money 50-50. And then Mom and Dad would sign the paperwork, hand it back to the banker, and the banker would take that information and input it into their computers. And the bank would have on file that these accounts do not go to probate. If the parents pass away and the family shows up with the death certificates, the banker can look in the files on the computer to see who's supposed to inherit. And they pay on death. No probate needed, no will needed. Unfortunately, nobody at Bank of America ever told my parents this information. Nobody at Bank of America ever told them that there's this free paperwork available. You have to be proactive. If you have checking, savings, stocks, bonds, CDs, mutual fund, money market, or investments, you have to be proactive and go out of your way to ask the bank for this free paperwork, but this free paperwork will keep your accounts from going to probate. Unfortunately, even if my parents had filled out that paperwork for Bank of America and for Charles Schwab where they've got their stocks, the house is the problem. Us attorneys, we like to say, the day you buy real estate is the day you have a probate problem. As you have seen on your deed, if you're married, there's 2 names on the deed, husband and wife. If you're single, there's 1 name on the deed. Not the kids, not the grandkids, not other family members who are inheriting. Only the owner's names are on the deed. And if my parents pass away, We do not own the house. My sister and I, we do not own the rental until we go to probate court and ask a judge to take mom and dad's name off the deed and allow us to inherit. We'd have to bring the will, our IDs, our information, and we'd have to go to probate court to ask a judge to get mom and dad's stuff. So I know you're asking yourself, how bad could probate court be? Well, my parents have a will that says that the girls get everything 50-50, and me and my sister are in agreement. But it's still going to take about 2 years for my sister and I to go through the court process. So for 2 years, we don't own the house, we don't own the bank accounts, and we can't sell the house. It's not ours. But of course, we have to pay the bills in the meantime. If there was a mortgage, we'd still have to pay that. But it's not even our house and our rental. Also, as you may have heard, probate court is very expensive. My parents, they have 2 houses paid off that are worth $1 million each. My parents have $2 million in real estate alone. Probate fees are a percentage right off the top. The money goes to the courts for filing fees and other fees, the executor, the attorney that's helping us with the probate case. We have to hire a court-certified appraiser to appraise the house and the rental. Even though we're not even planning on selling it, we still have to get it appraised. The court-certified appraiser, he's called a probate referee, and we have to pay that guy. We have to post a notice in the newspaper and pay the newspaper. And if my parents owed any money to any creditors are allowed to come in the court case and they get paid before me and my sister. For 2 years, we have to pay an arm and a leg to go to probate court just to talk about mom and dad's death over and over and over again. To have strangers involved in our lives at a time when we're grieving. It's awful. It's awful, especially when the kids don't get along. I'm sure you've heard court cases where the kids haven't even buried the parents yet and they're fighting over the money. If you have no will and no trust, that is a recipe for a fight between your family in court. And I'm telling you, even the people that have the nicest children, money turns kids rotten. Money changes people, and death and money combined with the stress of grieving sometimes makes the family fight. And then when the court case is over and the dust has settled and the family's paid through the nose, they never talk to each other ever again. I want your family to avoid probate. I want them to avoid the time, the public humiliation of it all, the cost, and I want your family to stay united. A will is merely a letter to the judge asking him who's going to inherit your stuff after probate. No will, no trust. If you have no documents, that's a probate. So, on your piece of paper, I want you to write the second way to avoid probate. And I want you to put a little picture of a house. This is a way to make sure that your house does not go to probate. Now, when I graduated law school 10 years ago, I started pestering my parents. Mom and Dad, let me do a trust for you. Mom and Dad, I'll do it for free. And my parents, they said, oh no, Sarah, we're not wealthy people. We don't need a living trust. And I said, Mom and Dad, you have real estate. You are wealthy people. And the day you have real estate, you need a trust or we have to go to court to get your stuff. And then my dad said something that was really surprising to me. He said, Sarah, honey, your mother and I, we have a plan. You're going to inherit the residence. Your sister's going to inherit the rental. And I've been talking to my buddies and we found a loophole. I said, really, Dad, what's the loophole? And he said 2 words. And yes, this is a valid loophole. And yes, I do want you to write it on your piece of paper. Number 2, the loophole is called joint tenancy. What is joint tenancy? Well, some of you may know the words joint tenancy before, but let me go over the basics. Joint tenancy means, first, multiple owners. When Mom and Dad bought the house, there was 2 owners and 2 signatures are needed to sell. If they're both alive, 2 owners. Number 2, joint tenancy means all owners are equal. My mom owns half and my dad owns half. Number 3, joint tenancy means right of survivorship. What does that mean? If one of my parents pass away, the survivor inherits all. No probate. So, how do people use joint tenancy as a loophole? Before we get into that, just a reminder, the code for the 50% discount is Angels Baseball. Here's what my parents were thinking to avoid probate. Here was their loophole. Mom and Dad were going to give me the residence and they were going to sign a new deed immediately. And the new deed for the residence was going to say Dennis, Sylvia, Sarah, joint tenants. If Mom and Dad signed that new deed immediately, starting today, there's 3 owners. I own a third, my mother owns a third, and my dad owns a third. If later on Dad dies, I now own the house with Mom 50-50 automatically. We survived, there's no court. If my mother dies second and I survived, I have inherited the whole house, no court. Joint tenancy, right of survivorship, last man standing inherits. Looks pretty good, right? Why not just add your kid to the deed while you're alive? Well, let me tell you why this is a terrible idea and you should not listen to my dad and his buddies. Number 1, if my parents signed that new deed today, starting today, there's 3 owners. And if Mom and Dad want to sell the house tomorrow, they need my signature. They need 3 signatures. And if I don't want to sell, they can't move. If Mom and Dad want to refinance, they need my credit score, my credit. If Mom and Dad want a reverse mortgage, they can't qualify for a reverse mortgage. You can't get a reverse mortgage with a 42-year-old on the deed. Not only that, my liabilities are Mom and Dad's problem. If I'm driving around drunk and I run over somebody with my car and I kill them, the person's family that I injured, they're going to come after that house. They're going to demand my 1/3, demand Mom and Dad sell the house because of my liabilities. If I have any bankruptcies or judgments against me, Mom and Dad's house is in jeopardy. If I have any creditors, heck, if I've stopped paying my student loans or defaulted on my car payment or stopped paying my credit card bills, my creditors can put a lien on Mom and Dad's house. Mom and Dad could lose the house because of my problems. This includes alimony and child support issues. Another reason why you don't want to add your kid to the deed, property taxes. If my parents sign the new deed, immediately I'm a new owner. They've transferred me 1/3 ownership. And anytime you transfer ownership, the county wants to reassess the property and raise the property taxes. My parents bought their house in 1980 when it was worth $100,000. Today it's worth $1 million. Under Prop 13, my parents are only paying about $2,500 a year in property taxes. Their property taxes are very low compared to the neighbors who just bought last year, who pay $12,000 a year in property taxes. If Mom and Dad listen to my dad's buddies and they put my name on the deed as a joint tenant, that's a change of ownership and the county is going to raise those property taxes. Not only that, if Mom and Dad sign that new deed, they've gifted me 1/3 of a house. Next April, there may be gift tax implications. And guess what? The kid isn't the one that pays the gift tax. The person that gives the gift is the one that pays the taxes. That's right. If my dad is listening to his buddies and they're trying to use this joint tenancy loophole, mom and dad might be on the hook for gift tax next April. Lastly, there are some capital gains, exemptions, and exclusions that may be lost forever if mom and dad put the kid on the deed while mom and dad are still alive. I could give a whole other seminar about step up in basis and capital gains tax, but for now, in lay terms, just keep in mind that if the parents put the kid on the deed while they're alive, it's like the kid was with the parents when they bought the house. All the gift capital gains tax exemptions are ruined. Now to recap, the reason why joint tenancy is a bad idea: liability, taxes, taxes, taxes. If you've already added your kid to the deed as a joint tenant because you didn't know any better, you didn't know about these tax laws or about the gift taxes or about liability, included in your services, we're going to do documents to make sure the house gets put back into your name 100%, so that you own this house until you pass away, but that it avoids probate. On your piece of paper, I want you to write number 3, the third way to avoid probate: a revocable living trust. What is a revocable living trust? It's a trust that you set up while you're alive and you are the owner and you are the manager, but if you die, your family only needs the binder and everything they need is already in here waiting for them. They have the legal ability to deal with the bank accounts, to deal with the real estate, to deal with everything, so they never have to go to court. No probate. If my parents pass away and they have a trust, the only thing my sister and I need is the death certificates and the binder, and we can go to the bank and immediately get their checking and savings, and go to Schwab and immediately get their investments. We can do everything we need to sell the house or put the house into our names. Everything we need is in here so we can avoid probate. That's why so many people have a living trust. This isn't for you. This is for the people you leave behind. So, let's quickly go over some of the definitions. And by the way, yes, my parents, they do have a trust. It took me years of badgering them, but I finally got them to do their living trust. It's called the Rinelli Family Trust. Now, if you have a trust, can you get rid of your trust if you don't want it anymore? Absolutely. Can you change it? Absolutely. But the day that you pass away, if you're single, the trust becomes set in stone, irrevocable. Irrevocable means it cannot be changed, cannot be modified. If your kids don't like what it says, tough. If you're married, the trust becomes irrevocable when both spouses pass away, set in stone when both are dead. So let's go over these definitions. I'm going to give you 5 definitions that are important. Number 1, trust owner is called trustor. Definition number 2, trust manager is called trustee. Mom and dad are the owners and the managers. They are the trustors and the trustees. Definition number 3, manager after death is called successor trustee. This can be anybody over the age of 18. In my situation, for my parents, their living trust says that if they pass away, me, Sarah, I'm their number 1 successor trustee. My sister is the alternate. Aunt Seal is the alternate to the alternate. The only rule is this person has to be over 18 years old. So, if your kids are still little, don't choose them. It's got to be somebody that is responsible. This is the person that pays all your final bills after you're gone, deals with the arrangements at the funeral home, gets everything handled, and makes all the distributions according to your wishes. Can they change your wishes? No, they cannot. They have to follow the directions. Definition number 3. Someone who inherits is called a beneficiary, same as always. Yes, your kids can be your beneficiary, but you don't have to leave them anything if you don't want. This is your decision. Grandkids can be beneficiaries. It doesn't have to be relatives either. You can leave inheritance for your friends, your church, charities. It can be anybody that you choose. You can decide who gets what. If they don't like it, tough. It's not up to them, it's up to you. You can also put some strings on the money. For example, I want my kid to get the inheritance, but not until they turn age 21. Okay. I want my kid to get the inheritance, but not until they graduate college. Okay. I want my grandson to get the inheritance, but not all at one time. I want him to get a little bit at 18, a little bit at 21, and a little bit at 25. Okay. I want my granddaughter to get the inheritance, but not until she takes a drug test. She got to be sober. Okay. And like I said, we're not here to help you. We're not here to judge you. We're here to help you. What if you have family members that are special needs, that are receiving some sort of government benefits? Can they get inheritance and keep their benefits? Yes. We're going to do special paperwork for them. It is free. It is included in your services to make sure that they never lose their benefits. Final definition. Someone who gets custody of children that are minors is called a guardian. Now, I know you may be asking yourself, what else is included in the binder, in the estate plan package? Well, obviously, in the binder, in the very first tab, we've got the living trust. We're also going to put a list of all of your finances, so your kids don't have to go on some crazy scavenger hunt to try to figure out where all your bank accounts are. You can also specify who gets which personal item if you want. It's not required, but you may want to say, my pearl necklace goes to my best friend. My tools go to my next door neighbor. You will be able to have a place to put that in here as well. We're going to give you a special will. I know I said wills were bad, but we're giving you a special kind of will. This is called a pour over will. It's like I've poured over a cup of coffee. Pour over will. A pour over will is important because it keeps everything from going through probate. Things you may have even forgotten that you own. Maybe you had a little bank account from college and you forgot about it. Well, this scoops it up and puts it into the trust posthumously. We're going to give you a financial power of attorney. This is a document that you decide who's going to do your finances in the event that you become incompetent. We're going to give you a healthcare directive. This is who's allowed to talk to the doctors if you cannot speak. We're also going to put other documents in here. A certificate that says that the trust is valid. We're going to put deeds to make sure that your real estate gets put into the trust. And various other documents are also included. Now let's talk about real estate real quick. If you have 3 pieces of property in California or less, we are going to do paperwork to make sure all 3 pieces of your California real estate get into the trust. We do all the documents for 3 California properties. If you have more than 3 pieces of property in California, we charge additionals for the additionals. As of the time of this taping, we charge $50 for the additionals. So if you have 3 pieces of property in California, 3 are free. But if you have 4, the 4th one costs $50. If you have any real estate that is outside of California, we charge $100 to deal with out-of-state property. Now, what is the process if you want to sign up today? And like I said, Angels Baseball is going to be the coupon code for the 50% discount. Here's how the process works. If you're interested in getting signed up today, call the office with your credit card information. One of our office staff, usually Cindy, she's usually in charge of doing all the new signups for clients. She's going to take your contact information and your credit card. She's going to charge your credit card, and she's going to send you some paperwork. She's going to send you a copy of the contract that says everything that's included that we just went over. It also says, if you change your mind, you've got 3 months to get a refund. She's also going to send you the homework. She's going to send you the contract and the homework. The homework is 8 pages of questions that you fill out at your house. It's a very simple questionnaire, but it asks very basic information like, who are you? Are you married? Do you have kids? If you die, who's going to get your stuff? Who's going to talk to the doctors if you can't speak? Who's going to do your finances if you're incompetent? It's also going to ask, what are your finances? Where is your real estate? Do you own any businesses? If you sit down and get this over with, it'll take you 1 hour to fill it out. You've got 6 months to turn in this paperwork, but don't wait 6 months. Just fill it out and get it to us as soon as possible so we can get started. If you have a question on here you don't know how to answer, you can call the office, and there's also another instructional video that I've given that explains page by page how to fill out this worksheet in case you're having a hard time. Once you've finished the worksheet, get it back to us, and you got to give us a little bit of time to type the binder. Now, normally it takes us about a month and a half to type the binder. If you have a surgery coming up, or you're feeling very sick, or you have a cruise coming up, or you have some sort of a rush situation where you can't wait 6 weeks to get this typed, I want you to call our office and communicate with us. We do have a rush program for people that are sick or really, really have an emergency, but it is an additional fee to skip the line. Once we've typed your trust, like I said, it takes about a month and a half. We're going to send it to you so you can read it. If you have any questions, call us. Come down to the office. Our office is in Mission Viejo, right near the Kaleidoscope in the Mission Viejo Mall. If it looks good, we want you to get this trust signed and notarized. And if you are in our network area, if you are 75 miles from Orange County, we're going to send a notary to your home free of charge. Now, if you are outside of our network area, let's say, for example, you live in Sonoma County or you're in Napa, in an area where we don't really have an office up there, you can get this notarized by any notary public. And if you go to their bank, they'll usually notarize this for you free of charge. AAA usually notarizes for free of charge or for a very small fee. The day this is notarized, it's valid immediately. Now, there are some other things that have to happen after this is signed and notarized. There are some documents that are going to be in the back pocket that require more attention. For example, your residence. We're going to do the paperwork to get your residence into the trust. And you're going to sign it with the notary. And then it's got to get mailed to the county. When the notary comes over, the notary is going to tell you where to mail this to. If you're outside of our network area, we're going to tell you where to send the new deed to the county. And just keep in mind, the county doesn't work for free. They are going to charge you about $20 for your residence. The notary will tell you to the penny how much you have to write the check to the county for. Now, we know that for some of you, this is tough to talk about. But we learned some very important lessons during COVID. We had clients that had waited years and years and years to do their living trust. And They were procrastinating. They were pushing it off until next year. And then they got COVID. Husband and wife got COVID. The kids got COVID. And then they were struggling to fill in their paperwork, to get it signed and notarized, to get it typed, the whole thing. I want you to do this when you're calm, cool, collected, and competent. Because we've had situations where the client called us, and they were already on their deathbed, and it does take us time to do this paperwork and to get it typed. Do this now while you're healthy. I know with Alzheimer's and dementia, there's warning signs, but COVID, we weren't prepared for. A stroke, a heart attack, a car accident, an earthquake. You can't plan for that. I want you to be prepared now, because this is the biggest gift you can give your family. Now, a couple other things before we finish. I just wanted to let you know that this living trust does protect your residents from your Medi-Cal bills. What does that mean? If you're in a nursing home and you run flat broke, they can't take your house. That is another great reason to have a revocable living trust. Just to recap, the revocable living trust keeps the family out of probate. No overhead, no fees. Everything the family needs is in the binder waiting for them. They never have to hire a lawyer. They never have to hire any help. Everything they need is in the binder. This helps you in sickness, so the family can help you if you become incompetent. It helps protect the family against taxes, and now it protects the family from Medi-Cal repayment. My name is Sarah Rinelli. We're happy to have you as our new client. Call soon before the price increases again. But this presentation has given you the coupon code for your 50% discount. We hope you enjoyed it and have a great day.